Good morning. Welcome back to Deb's True Crime Notebook. Grab a cup of coffee, sit back, and let's take care of some business here. We have a state's motion in limine regarding composite sketches. Let's see what the state has to say about this. State of Indiana versus Richard M. Allen. State's motion in limine regarding composite sketches. Comes now the State of Indiana by Prosecutor Nicholas McClellan for the 74th Judicial Circuit and respectfully requests that the court enter an order prohibiting the admission of reference to composite sketches prepared by any sketch artist for the investigation of the murders of Abigail Williams and Liberty German, for the reason that a composite sketch is not a relevant admission, would result in undue prejudice, confuse or mislead the jury, or is impermissible hearsay. And the witness who participated in the preparation of composite sketches will not be present by the state for the purpose of in-court identification of the defendant. In the support of this motion, the state would show the court the following. 1. The composite sketches prepared were intended as an investigative tool to generate leads to identify a suspect, and in fact, these sketches were not related to the identification of Richard Allen as a suspect. Therefore, the sketches would not be relevant under Indiana R. Evid 401. 2. That the witnesses who assisted in the preparation of composite sketches of the bridge guy would testify that they did not see the person depicted in their sketch for a sufficient length of time to allow them to positively identify the defendant. Therefore, again, under Indiana R. Evid 401, the composite sketches are not relevant evidence. 3. That if the court were to consider the composite sketches to be relevant, the probative value is substantially outweighed by the unfair prejudice, confusing the issues and misleading the jury, and therefore should be excluded under Indiana R. Evid 403. A composite sketch reflects the police artist's interpretation of someone else's depiction, based on the artist's synthesis of an infinite variety of facial features and configurations. Creating a composite sketch carries the potential suggestiveness of having a police artist interpret and possibly influence the perceptions of the witness. 4. That the composite sketches would be hearsay or double hearsay under Indiana R. Evid 803, in that the sketch is an out-of-court statement and a subjective rendering by one person using the subjective description by another person/witness and does not fall within a recognized exception. 5. It is the state's belief that the defense intends to use composite sketches from the investigation as demonstrative evidence and for impeachment purposes, that the witness who participated in the preparation of composite sketches are not being called to provide in-court identification of the accused. Furthermore, no composite sketch was instrumental in identifying Richard Allen as a suspect. 6. That the prejudicial effect of composite sketches far outweighs the probative value for in-court identification or of the accused and would likewise be inappropriately used to impeach a witness who is not presented before the jury to provide in-court identification of the accused. 7. The Indiana courts have not addressed this issue or use of composite sketches. Indiana courts have excluded composite sketches that resulted from the use of victim-witness hypnosis. Other Indiana cases discuss or mention the existence of a composite sketch in the course of an investigation leading to a probable cause to arrest, but no analysis of their use as evidence to impeach witness testimony. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court to grant the following relief. A. Order the defendant, his counsel, and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to composite sketches without first obtaining permission of the court outside the presence and hearing of the jury. B. To further order said person to make no reference to the fact that this motion has been filed and granted and all other relief just and proper in the premises. Signed, Nicholas C. McClellan, Attorney 28300-08. And there you have it, the first document of the day, motion in limine by the prosecution. Oh, why I'm at it, let me just say that correctly for everyone so I don't get any messages. In Limina or In Limine or In Limine. I hope I've made everyone happy. Oh, wait a minute. There's one more. In Lemonade. You guys have a great day. I'll be back. We have more to share with you. Don't forget to like, subscribe, ring the bell for all notifications, share this with a friend and your groups, and leave a comment. We love hearing from you.